We're going to call this meeting to order for the Board of Appeals, April 25th, 2017, to hear case MAA 1701, Michael Gonzalez, special exception, home occupation at 1605 Loxley Lane, Mount Airy, Maryland. Applicant is seeking approval to establish a home occupation for an internet-based firearms sales business. In response to inquiries regarding public comment at this hearing scheduled for tonight, depending on how the board proceeds, public comment may be heard. Persons interested in providing public comment at the hearing are notified that all testimony received at the public hearing shall be under oath and may be subject to cross-examination. At this point, we're going to, typically at this point, we would have Heather read the case from front to back. As many of you are aware, this case is coming to us with a negative recommendation from Planning and Zoning. Subsequently to that negative recommendation, the application for the special exception was placed. Subsequent to that, an ordinance was passed that would in turn restrict this use in residential neighborhoods. And at this point, it's my understanding that the town attorney would like to address the board.
Yes, Mr. Chairman, if I may proceed. First, before we proceed to the motion to dismiss, I do have a number of exhibits that I'd like to at least place in the record. We're in a posture where a petition has been filed actually before these proceedings. And these exhibits would be essentially the ordinances and other materials that are of public record.
In that event, go ahead and let Heather introduce the case so that the staff exhibits are in evidence, and then Mr. McCarron can add to the case file the items he wishes. Can you hear me? Am I on?
Yes.
Okay, I apologize. I was speaking to the chair and suggesting that Ms. Smith, because the town attorney wishes to add additional exhibits to the existing file, the file should be introduced first.
Okay. This is the staff report for the special exception request for the establishment of a home occupation for a firearms business.
Okay.
And I'm reading this into the record, correct? Just so I understand correctly?
Not the full staff report, just introducing the exhibits that Tom is going to refer to the.
Okay, I believe.
Summarize the posture of the case and describe the exhibits that are in the staff file. Can you do that?
Yes.
Am I confusing you?
I am at a loss. I do apologize.
Why don't you go ahead with the format in which you usually proceed? And that
Okay.
will be
Typically, I give the staff report.
Okay. Go ahead and do that.
Okay. So I will enter in to the record for the staff report. The petitioner is again Michael Gonzalez at 1605 Loxley Lane in Mount Airy, Maryland. The location of the property is the same, 1605 Loxley Lane. The zoning is R2. The property acreage is 0.44 acres or 19,149 square feet. The petitioner is seeking approval of a special exception to operate a home occupation for a firearms business at 1605 Loxley Lane. The petitioner seeks approval to operate an internet-based retail firearms business. Pursuant to the Town Code Section 1162B, all applications for special exceptions must be referred to the Planning Commission for recommendation. At their regularly scheduled meeting held on February 27th, 2017, the Planning Commission, by a majority vote, forwarded an unfavorable recommendation to the Board of Appeals, finding that the burden of proof would not be met by the applicant by a preponderance of the evidence that the specific unfavorable recommendation to the Board of Appeals, finding that the burden of proof would not be met by the applicant by a preponderance of the evidence that the specific and/or general standards would all be met. This finding was based in part upon the applicant not meeting the standards set forth in the Town Code Section 111262 F7D, requiring 2 additional parking spaces for the proposed home occupation in the rear yard. Further, the petitioner's request for waiver of the parking standard was not met with unanimous support. When considering the general standard 1C, the majority of the Planning Commission did not find, based on the evidence presented, that the applicant was likely to meet the burden of proof to establish that the value of the adjacent land would not be discouraged by the proposed use. The following specific standards as provided for under section 1112.62F7 for that proposed use are to be considered, and town staff comments with respect to each standard as follows. Standard A provides that the persons residing in the dwelling only may be employed or engaged in the occupation, and accessory structures on the property may be used for the home occupation. The applicant resides at the subject property in a single-family detached dwelling and will be the only person employed or engaged in the occupation. Based on the information provided by the applicant, the operation of the proposed occupation firearms business will not involve the use of any accessory structures. Standard B provides that the character of external appearance or the dwelling unit or accessory structure must be that of a dwelling or its accessory structure. No display or products may be shown so as to be visible from outside the dwelling. A nameplate not larger than 2 square feet in area attached to the building and illuminated only by indirect lighting is permitted. The home occupation will operate out of the existing principal dwelling structure located at 1605 Loxley Lane, and as proposed will not modify the character of external appearance of the structure, nor will it involve the use of accessory structures. There is no indication that the applicant will display products for sale in a manner to be visible from the outside of the dwelling. The petitioner has stated that a nameplate is not proposed for display on the outside of the home. Standard C provides that not more than 25% of the ground floor area of a dwelling unit may be devoted to a home occupation. The submitted application states that 250 square feet of basement floor area will be devoted to the home occupation. The petitioner has supplied a floor plan showing the location of the proposed occupation with an area measuring approximately 16 by 16. The total ground floor area of the subject dwelling unit is 2,412 square feet. The applicant is permitted to have the home occupation cover up to 602 square feet of the residence and therefore meets the standard. Standard D provides that besides the required parking for the dwelling unit, additional parking located in the rear yard is required as follows: 1 space for the home occupation and 1 space for each member of the immediate family employed in the home occupation. 3 additional spaces for a physician or dentist. A total of 3 parking spaces are required for the dwelling unit and are provided for with the utilization of the attached 3-bay garage. According to the site plan provided by the petitioner, the applicant proposes to provide for the 2 required parking spaces in the existing driveway areas delineated in the turnaround area as highlighted in yellow. Upon inspection of the driveway area, the site plan provided does not reflect the built condition of the driveway. Specifically, the plan provided delineates a defined turnaround area where the distance of the driveway at the greatest width measures 36 feet in width. The actual physical measurement at this point, however, is 27 feet in width. Additional measurements taken in the driveway do not yield greater than 30 feet in width. Photographs of the existing condition are attached to the staff report for reference. It is unknown at this time if the applicant proposes to enlarge the driveway to reflect the defined turnaround area shown on the submitted site plan, nor is it known if this area would be sufficient to accommodate 2 additional parking spaces as required. Additionally, the proposed parking area is considered to be located in the side yard area rather than the rear yard as stipulated by the standard. Consequently, the town staff has determined that the applicant does not meet this specific standard. The petitioner has requested a waiver of this provision in correspondence dated February 26, 2017. In the interest of full disclosure, town staff wishes to advise that a number of past home occupation special exception applications have been approved by the Board of Appeals without meeting this specific standard. In addition to the specific standards for the home occupation special exception, the following general standards must also be met as determined by the Planning Commission and Board of Appeals. General Standard 1A provides that the proposed use, including its nature, intensity, and location, is in harmony with the intent of the master plan and the orderly and appropriate development of the district. On March 6, 2017, the Town Council enacted as an emergency measure Ordinance 2016-27. As adopted, Town Code Section 112-12 prohibited uses specifies sales as a regular course of business or trade with the principal objective to profit, to include by way of internet, arm's length, or mail order transactions of alcohol, tobacco, or firearms, shall be permitted in the downtown zone, limited commercial, community commercial, and industrial districts, but shall be prohibited in all other zoning districts. The legislative body of the town of Mount Airy, through the adoption of the above statute, has determined that the proposed use is not in harmony with the intent of the town master plan and the orderly and appropriate development of residential districts within the town boundaries. General Standard 1B provides that adequate water supply, sewage disposal, storm drainage, and fire and police protection are or can be provided for the use. This home is already served by water, sewer, and all other public facilities. The home occupation being proposed will not cause an additional usage of public facilities at this location. As presented by the petitioner, the chemicals involved in the proposed home occupation use are paint thinner, oil wipes, oil drops, Old English furniture polish, or lemon oil, Flitz metal polish, and Pledge, lemon flavored. The chemical listing is currently under review by the local fire protection services for consideration by the Board of Appeals. General Standard 1C provides that the use of adjacent land and buildings will not be discouraged, and the value of adjacent land and buildings will not be impaired by the location, nature, and height of building walls and fences. This home occupation is proposed to operate in a small area of the basement of the existing house and will not be evident from the exterior of the building. No new building walls or fences are associated with the home occupation. As to whether the use of adjacent land and buildings will or will not be discouraged, the applicant will bear the burden of proving by a preponderance of the evidence that the proposed use will not discourage the use of adjacent land and buildings. The town has received a number of comments from town residents in connection with public hearings or meetings related to proposed ordinance changes related to these proceedings, that use of adjacent land and buildings will be discouraged. The petitioner has provided a comparative market analysis as evidence that other federal firearms licensed businesses in residential districts located in Carroll County and neighboring counties have not negatively impacted adjacent homes. General Standard 1D provides that the use will have proper location with respect to existing or future streets giving access to it, and will not create traffic congestion or cause industrial or commercial traffic to use residential streets. Persons involved in the home occupation will travel along Watersville Road, a major collector road, and then on to Loxley Lane and Kings Forest Trail, both classified as local roadways. The described intensity is not expected to create traffic congestion. General Standard 1E provides that the specific standards set forth in 11262F for each particular use for which a special exception may be granted have been met, except in the case of nonconforming structures where the board determines that no adverse impact will result. The petition for special exception considered under Town Code Section 11262F7 for the purposes of establishing a home occupation have not been met in their entirety. Specifically, the applicant has not demonstrated through the application submittal that the required parking standard is set forth in Section 11262F7D can be met. General Standard 2 provides that the applicant for a special exception shall have the burden of proof, which shall include the burden of going forward with the evidence and the burden of persuasion on all questions of fact which are to be determined by the Board of Appeals. Staff recommendation. Town staff is compelled to recommend denial of the petition for special exception of a home occupation at 1605 Loxley Lane, Mount Airy, Maryland, as all of the general and specific standards have not been met. Aside from the issues of whether the applicant can meet the specific standards relative to parking or the general standard relative to the impact of value of the neighboring property, recommendation for approval, condition or otherwise, would be in direct conflict of the current code statute prohibiting sales as a regular course of business or trade with the principal objective of profit, to include by way of internet, arm's length, or mail order transactions of alcohol, tobacco, or firearms. And that is the staff report for the record dated April 25th for case MAA 1701.
Are there additional exhibits?
I can go through them, or she can, either one.
Before we address the exhibits you want to add tonight, I'm just clarifying whether the staff file includes photographs or other materials.
Yes, it would include of course, the application,
Yes.
as well as attachments by the town staff in response to the application regarding the parking.
Yes. So along with the staff report, we would have the applicant's petition. We have photographs of the driveway area. And we have a supplemental information from the applicant dated February 26, 2017.
Have you numbered those?
I did not.
Would you like to?
I would love to,
Okay.
absolutely.
Attorneys.
So,
Sorry. Unless anyone would like me to have Heather read the staff report again, I'm going to turn this over to the town attorney to present a motion to dismiss this application for special appeals.
Okay, thank you, Mr. Chairman. As the chairman indicated, the town council on March 6, 2017, passed ordinance 2016-27, which clearly prohibits the proposed use. Specifically, that ordinance amended our town code section 112-12, which is a list of prohibited or restricted uses throughout the town, irrespective of the particular district at issue. The new language added by the new ordinance 2016-27 states as follows: sales as a regular course of business or trade with the principal objective of profit, paren, to include by way of internet, arm's length, or mail order transactions, paren, of alcohol, tobacco, or firearms, shall be permitted if and to the extent otherwise permitted as a use of right or special exception in the downtown zone, limited commercial, community commercial, and industrial districts, but shall be prohibited in all other zoning districts. In other words, the proposed use, the sale of firearms by the new ordinance, is clearly prohibited in a residential zone. The application is for property in the R2 zone. The ordinance was enacted as an emergency measure, which under our town charter, section C2-13B, takes effect or took effect immediately on March 6, 2017, when it was passed, voted on by 4 of the 5 members of the town council as such as an emergency measure, and signed by the mayor on that evening. The application, as I say, seeks a special exception for home occupation in the R2 zone. According to the application, what is proposed is an, quote, internet-based firearms business, unquote, specializing in the sale of, quote, vintage war-era firearms and related products, unquote. As I say, ordinance 2016-27 clearly prohibits this on its face. It also would prohibit, I believe, a finding that general standard under section 112-62E1A could possibly be met. That general standard requires the proposed use to be in harmony with the intent of the town master plan and the orderly and appropriate development of the district. I've cited some case law, which is only some of the case law from Maryland that addresses this. The law is clear that where there is a change in zoning law during the pendency of an application for special exception, the new law must apply to the pending application. And we've cited 2 cases, the most recent one, the McHale case from our Court of Appeals, 415 Maryland 145, as well as the Yorkdale case, a little older case, 1964, 237 Maryland 121. There are others as well that stand for that proposition. We've specifically called your attention to the case of Yorkdale. In that case, it specifically said that one can have no vested right without first and foremost obtaining a special exception grant, which has not happened in this case. Second, that the grant is fully and finally adjudicated in the courts without any remaining appeals left. And thirdly, that substantial physical alteration of the property has begun directed toward the proposed use. The Yorkdale case itself involved someone who was granted a special exception. The matter had been appealed to the circuit court and even beyond, was pending in the Maryland Court of Appeals when a change in zoning law prohibiting the proposed use, the indeed approved use under the special exception, took effect and was passed. And the Court of Appeals dismissed the appeal, stating that because the law that had been passed while the matter was on appeal in the court system prohibited the use, the appeal could not go forward. No vested rights, so to speak, or quote unquote, no rights had vested. Here we've got an application far short of the application, indeed the approval in Yorkdale. Because as a matter of law the proposed conditional use does not qualify for a home occupation special exception, indeed is expressly prohibited in residential districts, the application should be dismissed without going any further with this proceeding.
Thank you, Tom. Would the applicant care to respond to this motion to dismiss?
Not this time, no.
Okay. Any discussion amongst the board? I mean, at this point, our choice is to either make a motion to dismiss based on the legal site that the town attorney provided and/or proceed with the hearing.
I'll make a motion that we abide by the attorney to dismiss this whole action.
The proper motion is move to dismiss.
Move to dismiss.
So there's a motion to dismiss. Is there a second?
Second.
A second. A motion and a second. All those in favor? Aye.
Aye.
Any opposed? Passes 4-1 to dismiss. You had an opportunity to speak prior to that, but at this point, if there's no other comments, I'd like to make a motion to adjourn the meeting.
So moved.
Motion and a second.
The
Oh.
count 4-1.
4-0.
Okay.
She's not.
No, I know, just for audio, it was you said 4-1, so I just wanted to clarify.
Okay, I apologize.
No, that's,
Just a quick question. Will there be a response via a letter from the town on my denial?
All of the actions taken by the Board of Appeals are required to be taken by written resolution. So a resolution memorializing the decision to grant the motion to dismiss will be prepared and presented to the board.
Said another way, am I getting a letter?
In order, yes. You will get a written decision, yes.
Thank you.
Do I have a motion to adjourn the meeting?
So moved.
Second? All those in favor? Aye. 4-0. We're adjourned.